Hello, great people. Welcome back to Global Happenings today. We are so excited to have you again. The issue of Nnamdi Kanu and the federal government, guess what, is getting very interesting right now. I don't know where the federal government will go again. Nnamdi Kanu floored the federal government in the appeal court. They played gimmicks around it. Right now, he has floored the federal government again. This time around in the federal high court sitting in Umuahia. According to the news, the federal high court sitting in Umuahia on Wednesday ordered the federal government to pay a whooping sum of 500 million naira as damages to the leader of the indigenous people of Biafra, IPOB, Nnamdi Kanu, for forcefully abducting and renditioning him from Kenya in June last year. Presiding Judge Justice Evelyn Anyadike also declared Kanu's extraordinary rendition from Kenya as illegal and a gross violation of his fundamental human rights. Kanu has, through his special counsel, Mr. Ejimakor, challenged his abduction and extraordinary rendition from Kenya without any court warrant and demanded his restitution to his country of abode, Britain or Kenya, where he was before the abduction in June 19, 2021. Kanu's lawyer also asked the court to redress the myriads of violations that came with his rendition, such as the torture, unlawful detention, and the denial of the right to fair hearing, which is regarded by or required by law before anybody can be expelled from one country to the other. He demanded 25 billion naira as damages for the gross violation of his rights and the torture he was subjected to both in Kenya and Nigeria. Meanwhile, the federal government, in its preliminary objections, argued that the matter has already been entertained by the Abia High Court and that the said incident did not occur within the jurisdiction of the court. But the court struck out the preliminary objection, saying that where an incident occurred in two states, any federal high court in either of the states had jurisdiction over the matter, stressing that violation of Kanu's right began in Afaruku, Umuahia, and continued in Kenya. The court also held that Kanu's lawyer had successfully established a case of torture against his client, which the defendant labored in vain in deflate. In considering the prayer for damages, Justice Anyadike held that Kanu had been exposed to global ridicule, which requires global cleansing. The court therefore ordered 500 million naira in damages against the federal government. The respondent had no representation in the court, but Kanu's lawyer, ejimakor, thanked the court for granting justice to his client. Later in an interview, ejimakor said that the judgment was a victory for the oppressed people and commended the judiciary for remaining the last hope of the common man. He urged the federal government to obey the judgment and other similar rulings in Kanu's favor and release him without further delay. Ejimakor further told the federal government to return Kanu to Kenya, where he was before his abduction by the agent of the government on June 19, 2021. He insisted that IPOB is not a terror organization, contrary to claims by the federal government. Ejimakor said that terror organizations do not have defense counsel anywhere in the world, unlike IPOB, which has identifiable lawyers all over the world. He called for the deproscription of the pro-Biafra movement and the release of all its members in different security detention facilities. Other members of Kanu's legal team present at the court were Patrick Agazie, Ifeanyi Nwogu, Tochukwu, Franklin Ohaitu-Wazie, and Mandela Umegborogu. National President of Ohanaeze Youth Council OYC Iboyaka was also present at the court. Iboyaka called on President Muhammadu Buhari to show he has respect for the rule of law and release Kanu without further hesitation. He said that the entire Igbo youth, both at home and abroad, has continued to stand firm behind Kanu, who he described as a rare hero. Below are the 8-point relief sought by Kanu, which were all granted except the 25 billion naira in damage, which was slashed to 500 million naira. Accordingly, says I, a declaration that the arrest of applicant in Kenya by the respondent agent without due process of the law is arbitrary, and the respondents enforced disappearance of the applicant for 8 days and their refusal to produce the applicant before the Kenyan court for the purpose of applicant extradition are illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental human right against the arbitrary arrest to his personal liberty and to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 2. A declaration that the detention of the applicant in a non-official secret facility in Kenya and the torture of the applicant in Kenya by the respondent's agent is illegal, unlawful, unconstitutional, and amount to infringement of the applicant's fundamental right against unlawful detention, torture, and to a fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 3. A declaration that pursuant to Article 12, subsection 4 of the Charter, the expulsion or extraordinary rendition of the applicant from Kenya to Nigeria by the respondent within a decision taken in accordance with the law of Kenya is illegal, unlawful, unconstitutional, and amounts of infringement of the applicant's fundamental human right to a fair hearing and not to be expelled from a state party to the Charter except by virtue of a decision taken in accordance with the law as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 4. A declaration that any criminal prosecution of the applicant for the purpose of which the respondent unlawfully expelled the applicant from Kenya to Nigeria is illegal, unlawful, unconstitutional, and amounts to infringement of the applicant's fundamental human right to fair hearing as enshrined and guaranteed under the pertinent provision of CFRN and the Charter. 5. An order of injunction restraining and prohibiting the respondent from taking any further step in any criminal prosecution of the applicant enabled by the said unlawful expulsion of the applicant from Kenya to Nigeria. 6. An order mandating and compelling the respondent to forthwith restitute or otherwise restore the applicant to his liberty, same being his state of being as of 19 June 2021, and to thereon to repatriate the applicant to his country of lawful domicile, to wit, the United Kingdom, to await the outcome of any formal request the respondent may file before the competent authorities in Britain for the lawful extradition of the applicant to Nigeria. An order mandating and compelling the respondent to issue an official letter of apology to the applicant for the infringement of his fundamental human right and publication of said letter of apology in 3 national dailies. 8. An order mandating and compelling the respondent to pay the sum of 25 billion naira to the applicant, being monetary damage claimed by the applicant against the respondent jointly and severally for the physical, mental, emotional, psychological, property, and other damages suffered by the applicant as a result of the infringement of the applicant's fundamental right by the respondent. My God. Whoa. Finally. I think with this one, there is enough conviction that Mazi Nnamdi Kanu should be released from detention, and based on what this High Court have said, he must be extraordinarily returned. Let me use that language, extraordinarily returned back to Kenya, which was the way they picked him from. And with this, victory is not far away. Victory is within, because with this outcome, automatically it's in sync with what was said in appeal court, which therefore means that by now the young man should be signing some papers to be released from DSS, because if the government goes against this, automatically it may call for something that we will not be happy to see, because it will be a clear, war against the supremacy of the law, which already has been seen in the last case, the last appeal court case. Mazi Nnamdi Kanu is free, and with this, he should be released. I like to leave it there. What do you have to say? Listen to